Welcome to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Belomo, where we discuss all things estate planning and elder law, and, well, hey, anything else we want to talk about. Today is going to be a continuation of a prior podcast where we answered the common questions asked of an elder law attorney. Just as a reminder, please do not take anything that you hear from this show or any other radio show for that matter to constitute legal advice. If you are looking for legal advice, please call an attorney licensed in the state that you live in who practices in the area that you need advice in. And then and only then should you take something that you're hearing as legal advice. This show and any other radio show should be for informational and educational purposes only. And please, if you're in Pennsylvania, feel free. Reach out to us at Belomo & Associates at 717-845-5390 or check us out on the web at www.belomoassociates.com. We offer free educational workshops in the areas of estate planning, crisis Medicaid planning, special needs planning, and if a loved one passes away, trust and probate administration planning as well. In my law firm, I want to educate so that what happened to my family doesn't happen to yours. So please, if you're in need of educational information, check us out and we will provide the educational information absolutely free so that you are educated and know your options as you move forward into the planning arena. Well, Jeff, one of the questions I get all the time is, isn't a simple will good enough? Well, you know, one of the things that I tell in workshops all the time is a story called the two-finger test. And I ask people, please, if you raise your hand, if you have heirs, you know, everyone in the room raises their hand. If you have minor heirs, raise your hand. If you have disabled heirs, raise your hand. And then I wait and I go, we're all wrong. Take your two fingers, put them on the inside of your neck, and you should feel a bumping sensation. If you do, that means that you are alive. Heirs are not determined until when? Death. So if you have a heartbeat and a pulse and you are alive, therefore you do not know who your heirs are. And the significance of that is we can't plan for something in a simple base will without knowing who our heirs are going to be. So I'll give you an example. If I read your will to you, all right, hold on a second. So this is my psychic story. So I'm going to channel my inner psychic. I state your name, hereby make this my last will and testament. I hereby revoke all previous wills and codicils thereto. All just debts, expenses, cost of administration shall be paid first and foremost. My wife shall be the executrix of my estate. In the event that my wife Whitney shall predecease me, it shall be my oldest child. The executrix shall have the following responsibilities, and they shall include, but are not limited to, the following, about a page and a half of duties, and then it ends with all the rest, residue, and remainder, wherever situate, shall be given to my wife Whitney. In the event that my wife Whitney shall predecease me, to my children and equal shares per stripes. Well, it's actually stirpies. That's a legal term. All right, how did I do? Well, I read it to you, right? I just read a simple will to you. And here's the truth. A will only tells you what happens when you what? When you die. Guys, that's the easy part. That's the easy thing. The state has a rule book for you. It's called intestate succession. No, it may not be what you want it to be. I understand that, but at least there is something. A will gives everything outright to my wife. So let's say that I'm in a horrific car accident and she spends the rest of her life in a long-term care situation. The money doesn't go to her, right? Let's say that I'm in a car accident and then she ends up killing, 10 people in a car accident herself in a future incident. If that will leaves everything outright to her, that money is now taken. If that money is left outright to her in that will, as I read it to you, and she ends up marrying someone and then joining assets together, which a lot of married couples do, everything is gone, right? So those base wills don't protect the assets. They don't provide any sort of asset protection. Not to mention the fact that I may end up needing it or using it all because I didn't plan properly. And if I end up in a long-term care situation, the money is completely gone, right? The average cost of a long-term care in Pennsylvania is $14,676 a month. And in and around York and Lancaster counties, we're right around $13,000 a month. So how long until you are completely broke, especially if a husband and wife end up in a nursing home together? Guys, we have a lot of clients who end up in nursing homes together with their spouse. Why? Because the well spouse, the person who is caring for the individual that needs care, doesn't take care of themselves. So now you end up having a situation where both of them need long-term care. That isn't going to help anybody. And if you're looking at 30 grand a month, do the math on that to see how long someone's going to go broke. So planning is more than just simply a will, right? I used to poll rooms and ask people, when you think of the word, I hear the word estate planning, what is it that then comes to your mind? And people would always say, a will. Okay, well, a will tells us what happens when we die. How do I make sure there's money there when I die? How do I make sure that there's a document in place called a power of attorney that will authorize others to make decisions for me if I can't make them for myself? That's what we need to make sure that we have in place. That's what we need to make sure is there. So no, in most cases, a simple will is simply not good enough. Jeff, do you have to have a lot of money to need estate planning? No, right? Absolutely not. And I just gave you the example. Lots of people have rent, car payments, phone bills, utility bills. You don't have to be a millionaire to have those things. Well, here's the question. If you end up needing someone to make decisions for you, right? Who can do it? Who is the person that's going to be able to make those decisions? Well, if you don't have a power of attorney in place, nobody is. And then you're forced to go to a guardianship hearing in order to have somebody appointed on behalf of a loved one to make those decisions for you. Not ideal. Not ideal at all, right? You don't want to be in a situation where there isn't somebody authorized. The guardianship is, while a necessary component of the legal system, very emotional, very expensive. When you are relying on two attorneys, one for the alleged incapacitated individual, one for the person bringing the petition, a doctor, and a judge, that is going to cost money, way more than a power of attorney. So no, you don't need millions to need an estate plan. No, you don't need millions to have some documents in place to make sure that someone can make financial and medical decisions on your behalf. Everybody needs those. And yes, a base will is better than nothing, but certainly not necessarily what you need. So then the next question that we get is, do I need a trust then? Honestly, that question depends on, it depends, right? The answer is, it depends. First, let's identify what a trust is. A trust is a legal contract between three parties. The grantor, the person who creates it, the trustee, the person who controls it, the beneficiary, the person who receives it. It is literally a legal written contract between those three parties that talk about the roles of each of them and how they intersect with each other in a given topic or in a given trust, right? There are different types of trusts. There are testamentary trusts, which are trusts created under will. There are inter vivos trusts, which are trusts that are created during life. And there are two major styles, revocable and irrevocable. In the old days, we could use testamentary trust, which were trusts under wills, to do asset protection after death. Unfortunately, within the last couple years, many companies are no longer allowing us to name a beneficiary in a will to be a testamentary trust. It makes no sense. Nobody can give me a valid reason as to why. And all of the companies that are telling us no really won't tell us why, other than it's what we said, it's what we're doing, we're not going to allow it. And oh, by the way, it's not safe. Well, what do you mean it's not safe? Well, it's not created until death. Well, no, but neither is an estate. Yet a lot of companies, even the ones who say you can't do a testamentary trust, still allow us to do an estate as a beneficiary. Well, that also is created at death. So what's the difference? There isn't any. So nowadays, we're essentially not able to use a testamentary trust anymore, which brings us to the inter vivos trusts. The revocable trust is a trust that the person who creates it, the grantor, can essentially do whatever they want with the money, right? They can name themselves as trustee, they can revoke the trust, they can take everything out of the trust, they can give it directly back to themselves. Yes, all trusts that are inter vivos avoid probate. But not all trusts are asset protection trusts. So a revocable trust is not an asset protection trust. It is simply a probate avoidance trust, which there's plenty of reasons to want one. They provide great disability planning. Let the disability language in the trust document govern what will happen in case of a disability. Let's not have to leave it open to interpretation from a financial institution or a bank. Let's take it out of the court system. Let's allow it to be governed by the trust document, which will provide for a disability panel so that somebody can be removed if they're not acting in the best interest of the trust. Let's also name backup trustees. Let's name a trust protector, someone to be able to assist and step in the event that no one is authorized or no one has capacity to make decisions. All of it is handled within the trust document. Trusts are great for disability planning, right? And also, if you own assets in more than one state in your name alone, you would otherwise have to go through the will. The will would have to go through probate, and you would need to hire a lawyer in every state that you owned assets in. Most lawyers are not licensed in more than one or two states because you have to take the bar exams typically, and most attorneys who've been practicing for a lot of years don't typically take more than one state. So for example, I've been licensed over 20 years now, and I have no interest in taking another bar exam, right? I'm old enough now, I've been doing it long enough now that I don't have an interest in that. So to have to hire another lawyer in different states can become costly and expensive. So people with assets in different states oftentimes will want to avoid probate, which a revocable trust will do. Now, I do want to be really clear here. I'm going to talk about irrevocable trusts. The general term irrevocable means that you cannot be the grantor and trustee. You cannot be a beneficiary. You cannot have say over what happens in the trust. You cannot control what happens. You have to get a separate tax ID number. You have to pay taxes at a higher rate. That is currently for people with more than $12.92 million. And if they are married, another $12.92 million. Let's call that $26 million. We do not represent anybody who has more than $26 million. When I recommend a trust, I am not talking about an irrevocable tax trust, which is a trust that gets assets out of a person's estate. If I had a quarter for every time I got a call from a potential client who said, I spoke to my advisor and my accountant and they said that I don't have enough money to do this, I would be a very wealthy man. I am not doing this planning for people who have more than 12.92 million. I am doing it for people who have a couple 100,000 and maybe up to a couple million, 3, 4, 5 million. That's the range that we're in. Now, it happens to be the I word, but it's only the I word as it relates to giving it directly back to yourself. You can change the terms, you can change who gets it, when they get it, how they get it. You can change everything in the document, but you agree not to give it back to yourself. But the truth is, you will have the use and enjoyment of the assets. You will be able to live in the house. You'll be able to sell the house. You'll be able to buy another house. You can put the beach property in. You can put the cabin in. You can put the rental properties in. And you still get to sell it. You still get to rent it out. You still get to make the decisions for it. And it stays in your Social Security number. And you pay at your individual income tax rates. And yes, it is included for inheritance tax purposes. But as you've heard on these podcasts, we want it to be included for inheritance tax purposes Because we want that step up in basis. We want your kids to avoid the capital gains tax that they're going to have to pay if we avoid that inheritance tax. If you use the true irrevocable trust for tax purposes, it is outside of your social. It is a separate tax ID. You do pay higher trust tax rates. And your kids do not get a step up in basis. They get the carryover basis, which is the basis that the individual who created it has at the time they created it. And that is not what we're talking about. We are talking about people with a couple $100,000 up to a couple million, and they want what they worked their whole lives for to not just get taken in a couple months. They want to make sure that they're able to pass on a legacy. They worked their butts off, and they want to see that continue on. They want it in their social. They want it included for inheritance tax purposes because they want to step up in basis. Let me give you an example. If my dad paid $20,000 for a house and he puts my name on it, my basis is $200,000. I'm sorry. Oh my goodness. If my dad paid $20,000 for the house, my basis is $20,000, which is what he paid for it. If the fair market value on the date of death, or what it's worth, is $200,000, yes, I may have avoided the 4.5% inheritance tax if my dad outlived 1 year after my name was on it. But because of that, now when I sell it for $200,000, 200 minus 20 is $180,000 subject to capital gains tax at potentially 23.8%. You would be way better off paying 4.5% on 200 rather than 23.8 on 180. So the 4.5% is a good thing. Please come to a workshop, listen to the workshop, and we will tell stories in the workshop about how you want that step up. You don't want to avoid the inheritance tax. That is a great, great tax. You want it because you want that step up. All right? So for the purposes of our asset protection trust that we're using, we do get the step up. We do remain in control. We can't change any of the terms of the document. But because I can't give it directly back to myself, I do get asset protection once it is in there beyond the 5-year look-back period, which is 5 years. So you want it to be in there 5 years and 1 day, okay? And once it's in there, it is protected from the long-term care situation, which is a beautiful thing, especially because I remain in control. I remain and retain the ability to change the terms of the document, all which are wonderful things. The other question I get all the time is, Jeff, why do you use a radio flyer red wagon in every workshop, on podcasts, and everywhere you speak? Well, because it's simple. It's easy to understand. We can all relate to a radio flyer red wagon from when we were kids. I had one. You're darn right. I had G.I. Joe figures in there. I had rocks in there. My sister would make me put Barbie dolls in there, right? No problem. It's what's close to me. It's what I cared about. It's what I wanted to retain and keep. Well, that is what a radio flyer red wagon is as an adult. Now it's your house in there. It's your investment accounts are in there, right? Essentially, the only thing that we're probably not going to put in are going to be hot assets, which are boats, cars, guns, and retirement assets, qualified accounts. Qualified accounts cannot go into a trust during life without triggering taxes. So we'll leave those out. But just about everything else can go in. And because it's still in my social, and because I still pay at my individual income tax rates, it is not a big deal. It is not what we think of when we think of that I word, which is why I'm not using it. It's only the I word as to one item, and that is that I can't give it back to myself. But I can live in the house. I can sell the house. I can buy another one. And if I needed to get it out, I could, and I could get it back tax-free from the gift tax, all right? That is not the trust that people think of. Jeff, why do you tell people not to do research on the internet? Because when you type in that I word, the only trust you're going to learn about are tax trusts for people with more than 12.92 million. And everything that I just told you about isn't going to be there. Why? Because tax trusts are all you're going to find. That's all the attorneys will put out. There are very few of us who understand these style of trust. There are very few of us who draft these styles of trust. There are very few of us who understand it. And it costs a lot of money to be able to truly understand it. When I joined a national organization, By the time I went there, I was there for a week, and I got home and I got access to the software and I learned how to use them. I spent $20,000, the last 20 grand we had on a line of credit. And it was the single best decision I've ever made in my life. Well, other than, of course, marrying my wife and having a daughter and, a lot of other decisions. But in my professional career, it was the best decision that I have ever made because I learned about something that nobody knows about. Yes, I trained for that national company. Yes, I teach these trusts all over the country. But I'm not going to put the information out for free because I had to spend the money to get it. And so do the hundreds and thousands of people that I have trained over the years because it's valuable information. So we don't have it out there. You're not going to find it. Unless your advisor and your accountant have worked with us, they also probably aren't going to be familiar with it. So it is very dangerous to ask for advice from people who don't do this on a regular basis. Please bring them to the workshop. Please let them come and get educated. We offer boot camps several times a year for professionals, and they can come. They can ask me any questions. I'll teach them. But to give advice when it's not something that you're familiar with is scary. It's risky for the advisor, and it's risky for the client. So make them a part of the process. Let them get educated so they can learn about something that they don't know a ton about. Another question that we get asked all the time is, isn't Medicaid simply for poor people and it's bad care? No, that is just not true. Guys, almost every nursing home in the area has to accept Medicaid. Why? They wouldn't make it if they didn't. It is very few and far between for people who can afford to pay at the tune of 13, 14 grand a month for an indefinite period of time. In and around York County, the continuing care retirement communities all accept Medicaid. The best nursing homes all accept Medicaid. No, it's not just the county home. It's all of them, right? There's literally one that doesn't, and it won't be long, in my opinion, before they have to as well, because the system wasn't built for us to be able to continue to pay privately forever. People have to qualify eventually. And the government says you can do so either because you're spent down or because you planned ahead. And currently, there are crisis rules that allow you to plan in crisis, but you never want to rely on that because the rules could change anytime. And if one of the spouses passes, you are significantly hindered and hampered in what you can do and what you can protect. So you're better off planning ahead, getting the asset protection done correctly, and no, it is not worse care. Jeff, can't I just give all my money away? Well, as many of you have heard me teach the three lands, there is a tax land, a long-term care land, and an estate planning land. In estate planning, we want to control our property while we're alive and well. In tax land, we're allowed to give away up to $12.92 million during our life, at death, or a combination of the two. And if we're married, we have an additional $12.92 million to do the same with. But if we give it away, a gift is non-take-backable. A gift is a four-letter word. It is a bad word. Please stop living in tax land. Guys, we don't represent anyone currently who has more than $26 million. It is very rare for people to have a federal estate tax problem now with the estate tax where it is. Yes, it may come back in 2026. At least that's what it's set to do. But you're still looking at 6 or 7 million a person. So you're still at like 14 million, which would still be an extremely small percentage of the United States. So stop trying to eliminate something that doesn't apply to you anyway. And if you give it away when you end up in long-term care land, you have a problem. There is a 5-year look-back period. They are looking for gifts. They are looking for what you got away or gave away. And just because you were allowed to do it in tax land doesn't mean that you should. Okay? So please, thank you for taking that advice and just trusting me for now that that isn't the move that you want to be making. It just doesn't make sense. And no, you shouldn't just give your assets away. You have worked your whole life. You need to remain in control. That is the parting words for today's podcast. You've worked too hard to give up control and to put assets in other people's names. And that also includes jointly owned assets. You don't want to be doing it, all right? Thank you for joining the Red Wagon Estate Planning and Elder Law Show. I am Jeff Bellomo, and I hope you enjoyed the time today where we answered the commonly asked questions of an elder law attorney, part 2. This is the continuation of an original one that we started, and I will be doing another one because there are still more questions that I haven't answered. So, thank you for joining us today. If you're looking for education, please call the office at 717-845-5390. Check us out on the web at www.bellomoassociates.com. Thank you for attending the Red Wagon Estate Planning and Elder Law Show. Until next time, we'll see you real soon.